Hi, my name is Paul Zarefsky and I'm a Deputy City Attorney here in San Francisco. And for the next hour we'll be discussing open government laws. It's a very important subject because in a healthy representative democracy it's critical that the ultimate rulers, the people, have access to information about their government so that they can monitor their government. They can make judgments about the conduct of their public officials and the effectiveness and wisdom of their public laws. Now, I'm not telling you anything you don't know, and I'm sure all of us share that commitment to open government. So the purpose of today's training is simply to enhance your understanding of those basic principles, to get into some of the concepts in a little more depth, to cover some of the details more than you may be accustomed to. There are three laws that form the backdrop for our discussion. The Ralph M. Brown Act, which is the state law that governs open meetings, the California Public Records Act, and then finally our local San Francisco Sunshine Ordinance, which in certain respects enhances the transparency requirements of the two state laws. We can't cover other laws in this presentation. We can't cover all of the issues, and it's important to emphasize the general principles which we will discuss don't always answer fact-specific questions that you may have. But your Deputy City Attorney can answer those specific questions, and furthermore, we have on our website our Good Government Guide that often provides general answers. We're going to first discuss open meetings and then later in the presentation public records. The three main topics with respect to open meetings are number one, the notice requirements, number two, the rights of the public at meetings, and number three, defining a meeting, which may seem a little academic, but it's actually very important because essentially if you're in what the law recognizes as a meeting, all of the open meeting requirements kick in, and if you're not in a meeting, they don't. We will have a little bit of discussion of two secondary topics, closed sessions and passive meeting bodies. So first we discuss notice of meetings. The basic rule is a 72-hour rule before the meeting, whether it's a regular meeting or a special meeting of the body. And the posting of the agenda has to be in two places. It has to be at the public library, which is open 7 days a week, and it has to be on the website of the department or the commission in question. In addition, it's a good idea, it's not legally required, but we do recommend that the agenda for the meeting be posted at the departmental office and at the meeting room where the meeting will take place. The important thing about the 72-hour deadline is not so much a legal rule, but a practical rule, which is don't wait to the last minute because as the phrase goes, things happen. And so you should have an internal process where you're finished with your agenda and you get it on the website, you get it over to the library early in case there's some sort of snafu. Sometimes it's necessary to amend an agenda item, and if you're able to do that before the 72-hour period, then no problem. If it's after the 72-hour period, you can amend an item if you're not really changing the content of it, but you're just providing more detail to provide information to the public. But what you can't do after the 72-hour deadline is really add things or change things in substance to the agenda item. The basic standard for notice is that the agenda items have to be sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected of a reason to attend the meeting or to seek more information on the item. It's sort of a reasonable person standard. And it's important also that the item be described as either a discussion item or an action item, or sometimes where it's not clear when you're preparing the agenda, a discussion and possible action item. And the agenda also needs to refer to explanatory documents that relate to the different particular agenda items. Now, this aspect of having a meaningful description is where policy bodies, boards and commissions can get into trouble. You have to be careful about how you word these agenda items, and I have here some questionable descriptions. If you have an agenda item relating to real estate and you have like the formal legal description, but you don't have the address or something that would be more meaningful to the public, that may be a problem. If you have a contract and you just name the contractor, but you don't have anything about the amount or the duration or the purpose, that may be a problem. If the agenda item is about some legislation and it just says SB 123 or something like that with no subject, that may be a problem because in all of those examples, the public may not be given a meaningful description. And these last two are also possibly problematic. If you just say new business with no specifics, that doesn't give the public notice of what will be discussed. This final one, director's report, is more complicated. It's perfectly fine, and it's quite common for policy bodies to have on their agenda a director's report or a commissioner's announcements. And to the extent those items are really about announcements, where it's just a brief report of something that has happened, that's completely fine, because an announcement is really not a discussion item. But it's important, if you have one of these general categories like commissioner's announcements or director's report, that it doesn't become a lengthy, in-depth report that is more in the nature of a discussion item, and that the other commissioners not engage in an extended discussion about it. Then you can be in difficulty. Why does all of this matter? The description is critical because the policy body, which is the technical term we use for boards and commissions and advisory bodies and committees, a policy body cannot discuss or act on items that are not on the agenda. The agenda is your roadmap to the entire meeting, and you can't go off the road. You can change your direction a little bit in order, if you want to kind of move one agenda item up or down or something like that. You have to announce it as soon as you know you're going to do it. So you do have that limited flexibility, but you can't get into things that aren't on the agenda. Now, there are very limited exceptions to what I just said, and I always sort of question myself whether I should even have this slide in this training presentation, because it is so rare for most policy bodies. There are some exceptions, but it's so rare that there really is an emergency kind of situation that would warrant a body discussing something that's not on the agenda. There are other situations where it's okay to get into something at a meeting even though it's not agendized, and the reason is these things that are listed here as exceptions are not discussion items. They're not action items. They're just kind of other things that can happen in a meeting. Announcements I've already discussed, a request to agendize items for the future, directions to staff to research a matter, and when there is general public comment, if there's sort of a limited follow-up to clarify what an issue may be so that perhaps it could be agendized in the future. So those are some very limited exceptions to the general principle that something has to be on the agenda if the body is going to get into it. There are a number of requirements, some of them listed here, for things that have to be put on the agenda as a matter of instructing the public about kind of different basics relating to the meeting, the date, time, and place of the meeting, that there's a process for disability access and disability accommodation, notifying the public of their rights under the Sunshine Ordinance, notifying the public of where agenda materials are located, and particularly materials that were submitted, for example, by staff after the agenda was posted. There are some specific requirements of the Sunshine Ordinance relating to the ringing use of cell phones, chemical sensitivity, and so forth. And this is only a partial list, and it's really just kind of a reminder to commission secretaries in particular to be sure that there are the required informational kinds of notices like this on the agenda. So those are some of the basics about agenda notice. We now move to the second major topic, which is rights of the public at meetings. There are four basic rights: the right to attend the meeting, the right to record the meeting, the right to comment during the meeting, and the right to receive agenda materials. These are the four basic public rights. The right to attend is perhaps the most basic of all. The idea of open government is that people are able to come into the meeting and observe it. There can't be discriminatory admission policies. The meeting has to be physically accessible. It doesn't do any good to have the meeting in a building if the building is locked, for example, to the public. The building has to be accessible to persons with disabilities. There can't be any preconditions, like you have to file something, like you're going to attend the meeting. There can't be a fee to attend, and there's no requirement. There can't be a requirement of a sign-in sheet. It's okay to have a sign-in sheet if it makes very clear that signing in is optional. The right to record the meeting is very important because that's a way in which the meeting can be transmitted to a much larger group of people than may be present in that room or may be watching it on television at a particular time. And really any medium is acceptable: photography, video, audio. The body can curb the right to record, but it's an extremely high standard. The body has to make a reasonable finding of persistent disruption. It's a standard that's going to be very hard to meet. And so as a practical matter, bodies should accept the fact that people have the right to record the meeting and do what they can to accommodate the person doing the recording. The right to record includes a right to a live broadcast. Now, the city is not obligated to provide recording equipment to anyone, but you do have to try to work with someone who wants to record so that the setup is done in a way that is feasible for them and doesn't interfere with the body's meetings. The right to comment is probably the one that those of you who are on boards and commissions are most familiar with. It's maybe the most controversial. It's certainly where the most colorful things happen in these meetings. There are two types of comment. There's general public comment, and that can be scheduled at any time in the meeting. There also is what we would call agenda item comment. And the idea here is that if you have an action item, the public comment has to occur before the action is taken. Because obviously if it occurs after the action is taken, it sort of becomes moot. If it's just a discussion item, the requirement is that the comment occur sometime during the agenda item before consideration of it ends. Could be at the beginning, could be after there's a staff presentation, could be after there's discussion by the members of the body, just so long as it's before consideration of the item ends. As far as general public comment, a few basic principles. Number one, it should be agendized so that a person can see that on the agenda there's an opportunity for general public comment. It's important to emphasize that members of the body may not discuss general public comment or respond substantively. As I mentioned earlier, a limited follow-up to ask clarifying questions are okay. But the members of the body are not supposed to discuss this, because then in effect what they're doing is they're getting into discussion of a subject that has not been specifically agendized. And then with respect to regular meetings, general public comment is required. Special meetings, it's optional. It's perfectly fine, and many boards and commissions do have a practice of allowing general public comment at a special meeting, but it's not required. However, I would kind of add a little footnote to that, which is sometimes a special meeting, which is a meeting that's held at a time or place different from the regular meetings. Sometimes it's just a rescheduled regular meeting. You have to postpone the regular meeting for whatever reason. And in those situations, you definitely should allow general public comment because even though it's technically a special meeting, it's in the nature of a regular meeting. As far as the speaker's rights go, it's critical under the Sunshine Ordinance that we adhere to the so-called equal time provision. The basic idea here is that commenter A gets the same time to speak as commenter B. And this is, of course, to prevent favoritism or discrimination, either against individuals or against different viewpoints. In terms of calculating the time, to the extent there are interruptions from the chair or from a member of the commission, to the extent there's Q&A, that does not go into the calculation of the speaker's time. Now, it's important, this is sort of a subtle point, but important one, that the equal time requirement applies to people we would consider members of the public. And there are some people who participate in meetings of policy bodies that are not considered members of the public. The best example would be if, let's say, you're a department head and you're providing a comment at a policy body's meeting. You're not a member of the public. You're there speaking in your capacity as a member of the government. And so you're not held to whatever the equal time requirement is for just pure members of the public. If you have a situation, as sometimes occurs, where there's a translator, the law requires that double time be given. And then finally, if there's a need from a disability accommodation standpoint to provide extra time for the speaker, that should be done as well, so long as it's a reasonable accommodation. Other rights of the speaker. There's a right to anonymity. It's okay for the commission to ask for a name if they want it in terms of their meeting minutes, or if they have speaker cards and they want to somehow organize the speakers. But it's important that it be clear that it can't be insisted on. There's a right to anonymity. Just the way you can't have someone be required to sign up for a meeting, you can't really require a speaker to give their name. The second one is very important, right to criticize policies and people. And there's a right to be unpleasant. And, the fact of the matter is, if you have a thin skin as a commission chair, well, maybe you should be in a different line of work, because sometimes these comments can be really obnoxious. That's certainly a minority of comments, but it happens. And it's important to recognize that, while civility is something we should strive for, and while it's perfectly fine for a chair to request it, the public has a right to criticize and to do it in a way that may not be, real pleasant. And the speaker has a right to choose their method or medium of expression. For example, if they want to show a photograph or a video or something like that, so long as they are able to do it. They're still stuck within the time limits, but they sort of have their choice of medium. What sort of limits are there on public comment? The law says there's a right to up to 3 minutes per item, and that's been interpreted by the courts that it's okay for the policy body to do lower than 3 minutes if there are reasons for doing it. The number of speakers on an item, the complexity of an item, the number of items on the agenda, the time frame for the meeting, all of those different kinds of things. There's no right that the speaker has to speak off topic, and chairs are able to say, well, you need to get back on topic, or else we'll cut back on your, or else we'll, cut your speaking time. But it's important for chairs to be relatively tolerant on this. Sometimes you can spend more time getting into an argument about this than it's worth. But still, it is required that speakers speak on the topic. The speaker has no right to disrupt, but it's important to say that offensive comment is not disruptive comment. There's no right the speaker has to get any response from the body, and it's commonly the practice that members of the body do not respond to public comment. And there's no right to remote public comment following the pandemic. As you know, during the pandemic, that's how public comment worked. There's no right to it now, with the exception of if it may be necessary to reasonably accommodate a person with disabilities. It's really up to the particular body whether or not they allow it. And then finally, there's a right to agenda materials that the public has. Materials that are intended for distribution before the meeting should be available to the public before the meeting, so they have a right to inspect and copy it. If there are materials distributed during the meeting before the item is heard, there's a right to inspect those materials. If possible, if it's particularly materials from staff, you should have copies for the public if possible before the item's heard. If the materials are distributed when the item is heard, it depends on if the source of the materials is the department, the policy body, a member of the public. If it's the department or the policy body, if at all possible, those materials should be available. Now, I want to have a brief interlude here for a couple of items that don't fit within our three main topics, but sort of fit here and are important to mention in this training. It's a good practice to be sure that you adhere to the rights of the public to comment. It's a good practice to ask for public comment on each item. With respect to voting, it's required that after the vote on an item, that the chair or the secretary announce the specifics of the vote. Not just the item passed, but if it passed unanimously, you could say that. And if it doesn't pass unanimously, you need to specify how the different commissioners voted. As far as sequencing agenda items, I mentioned before, if you choose to resequence them, you need to announce that right away. On the other hand, if an item has been scheduled for a specific time, you can't take it early because you've given notice to the public it's going to be at that time, and members of the public may have come at that time, so you can't sequence it early. Finally, what about defining a meeting? This is very critical, as I mentioned. Basically, the idea is it's a majority of the policy body, and by that we mean of the seats. If it's a 7-seat body, you have to have 4 people for a meeting. They're together at the same time and place, or as we'll see, they could be together. When I say could be, to meet the definition of meeting, they may be in an illegal meeting if they're together via communications that aren't public. The subject matter of the discussion it should relate to at least to city business, and in some circumstances we would be a little more liberal about that as far as it relating to the business of that particular body or commission. These are fact-specific kinds of inquiries. There's not going to be a violation if a majority of a body happens to be in an elevator somewhere or whatever and discuss the weather, but members of commissions where there is a majority present should be careful not to discuss the business of the body. Now, legal meetings, obviously the formal meetings we're all familiar with. In addition, retreats, if done properly, and by that I mean retreats have to follow all the requirements in terms of notice and public comment and so on. Site tours, the same thing. Sometimes it's necessary or desirable for a policy body to have tours of a site, and that's fine, but again, there has to be a way for the public to access the site and a way for the public to comment and so on. And there are other requirements we don't really get into in this presentation, like charter bodies have to record their meetings, and so if it's a charter body, you have to kind of work that out. And then the Sunshine Ordinance provides that if you have a meal gathering immediately before, during, or immediately after a formal meeting, that's considered part of the meeting itself. Now, this is sort of the key when we talk about meetings, that some meetings are illegal. In other words, you have a situation that involves a majority of the members, but it's not done through a publicly noticed meeting. And you could have what I call pre-meetings or post-meetings. You have a majority of the commissioners there 15 minutes in advance, and they start to discuss agenda items among themselves. Or after the meeting, they kind of rehash the substance of the meeting among themselves. Or there's a recess in the meeting, and you've still got 5 commissioners up there, and they're talking about substantive items there. So in those situations that are sort of surrounding a meeting, you want to be careful to avoid those kinds of possible illegalities. And then in addition, there's what we call seriatim meetings, just to kind of make it complicated, to put some Latin in there. It means serial meetings. And the idea here is that, for example, you have 4 commissioners of a 7-member body, and A talks to B about the particular topic, and then B talks to C about that topic, and C talks to D about it. And all of a sudden, a majority of the members of the body have discussed this subject matter of the body, but they've done it in a non-public forum. Or you have one member of the body who talks to B, and then they talk to C, then they talk to D. You know, same sort of thing. Or you could have, you know, just kind of a joint communication. You have an email that one commissioner sends to a majority of others. Now, there is a doctrine that if all you have is a one-way contact, there is a doctrine which would say that's not really a seriatim meeting. It's just one member of the commission announcing their views, like having a press conference. But as a practical matter, particularly with email, you know, when this happens, somebody's going to reply all, and all of a sudden you have a discussion that involves a majority. So we highly discourage this. Seriatim meetings can occur in person. They can occur through email, text message, phone call, fax. They can occur through human intermediaries. That is to say, you have one member of a commission who has an aide or has someone else with interest in an issue, and that intermediary acts on behalf of the commissioner and contacts others and so on. That could be an illegal seriatim meeting. There are some exceptions to things that involve a majority but are not considered meetings. And they're not considered meetings just because the law accepts them, EXCEPTS, from the definition of meeting. For example, a non-member of the body communicates with a majority. That would be like a member of the public exercising their rights as a citizen to talk to every member of this commission or whatever. That's perfectly fine, provided these are one-on-one communications. It's not a communication with more than one commissioner. And during the discussion, the views of other commissioners are not discussed. So the idea is to preserve the integrity of the ability of a member of the public or even a member of the staff to talk individually to commissioners, but to have these strict guardrails against getting into illegal meeting territory. There are certain kinds of meetings of a majority that are just considered not formal meetings where the rules have to apply. If you have a majority of commissioners that attend a regional or national conference, for example, that deals with the subject matter of their commission, that's fine. Or if you have a local meeting that hasn't been generated by the city, but it's a local meeting relating to a community concern, that's fine as well. But it's important to recognize in these situations, these non-meeting meetings, number one, have to be open to the public. And number two, the majority of the commissioners who are in attendance can't collectively discuss the business of their commission. They're there to learn. They're there to perhaps participate in the meeting, giving a lecture maybe, whatever it may be. But there's no collective discussion of business. There are other examples, a social or ceremonial event that's not sponsored by or for the body. You know, the mayor sometimes has these ceremonies where people take an oath, you know, when they're entering the office. You know, it's okay for a majority of the body to attend such a gathering. It's just important that it be purely social or ceremonial, that it's not sponsored by or for the body, and that there's no collective discussion of business. There's also a particular rule that relates to a majority of a body attending as an observer at a meeting of a standing committee of another body. Generally that's okay, but the rules here get pretty complicated. So in this area, and actually in all of these areas I've mentioned of non-meetings, this is a prime area where you should discuss it with your deputy city attorney, because the facts really matter here, and it's really easy to inadvertently cross the line and end up having an illegal meeting. And that's why we recommend to check with our office about these kinds of situations and others. Policy bodies are boards, commissions, advisory bodies, etc., and they're the ones that are subject to the open meetings rules. And they're created by charter, ordinance, resolution, or other formal action or initiative of a policy body, or a federal or state grant if city officials or employees appoint members to the body in connection with the grant requirements. It can be a committee of the parent body, regardless of the committee membership, regardless of the nature, the purpose of the committee, regardless of whether it's a standing or ad hoc committee, then it's a policy body. And sometimes if you have an assignment by a commission of a task, investigating such and such matter, to two or more of the body's members, that can be an informal committee that's been inadvertently created. So in those situations, again, we suggest discussing the issue with our office, and we often will suggest, well, just have one member of the committee serve as the investigator or the point person. Sticky questions can get involved if the chair of the body forms a group. Is that a policy body, or is it just sort of something the chair has done on their own? That's again something where you really need to check with our office, because it may well be that the actions of the chair will be seen as acting on behalf of the commission and creating a policy body. What is not a policy body? An individual, solo member of the policy body, a hearing officer, department head. When these individuals are acting, they're not subject to the various open meeting requirements. If you have multi-member bodies that somehow are not created by the charter, ordinance, resolution, etc., then they're not policy bodies. We now want to just briefly discuss two other important aspects of open meetings, closed sessions and then passive meeting bodies. Even though the concept of open attendance is critical to all of this, the law does recognize the need for certain types of closed sessions dealing with personnel matters, pending litigation, instructing a labor negotiator, instructing a real estate negotiator, security matters, and then there are miscellaneous other more specialized kinds of closed sessions that the law recognizes. And what we want to do is just have a quick checklist of requirements before closed sessions, requirements during closed sessions, and requirements after closed sessions. Requirements before, there are specialized agenda formats for closed sessions. And this is another area where it often will be useful for the commission secretary or whoever it is prepares the agenda to work with our office on that, because it's easy to inadvertently make errors on the agenda formats for closed sessions. It's critical that there be an opportunity for public comment before the body goes into closed session. And the reason for that is, number one, the public comment can say, hey, you shouldn't go into closed session, you should have this in open session. And second, if there's going to be any action taken in the closed session, remember that principle, you have to allow public comment before action is taken. As far as the bodies deciding to go into closed session for pending litigation matters, the law requires that there be a vote. For other closed session matters, there's not a strict legal requirement to vote. Often it is the practice of policy bodies to vote, or their bylaws may say it or whatever, and that's fine. Requirements during a closed session. You got to stay on the topic. This is absolutely critical because you have to remember the closed session is exception to the general rule about everything being open. And so we're going to be construing that exception narrowly in order to be faithful to the open government principles of the Brown Act and the Sunshine Ordinance. So you have to stay on the topic. The closed session is not a license for, just discussing a lot of things. Our Sunshine Ordinance requires that the closed session be recorded. And that's sort of a safeguard to make sure that it's not abused, you might say, by commissioners, that they stay on topic and that the closed session is used for its proper purpose. And then finally, attendance needs to be limited in closed sessions to commissioners, to staff, if you need a staff member there to record things, if you need particular employees there in order to assist the body. And that's the general standard, but it's important to emphasize that there should be sort of a high level of need, that we shouldn't have a whole lot of extraneous people in closed sessions or anything like that. And if one person from a department is all that's really necessary in order to inform the commission on something, well, don't have more than that. And it's just a pretty high standard. It's hard to be absolutely mathematical about that standard, but please understand it's a high standard for people who are not commissioners to be in attendance at the closed session. Requirements after the closed session, there's a notice of requirement of certain types of actions taken in the closed session. Not all actions, certain specified actions in the law. And this again is a complicated legal issue where you're going to want to check with your deputy city attorney. There is a requirement imposed by the Sunshine Ordinance that when you come out of closed session, you have to vote in public whether to disclose any of your discussions. So that's an important process step. Be sure not to forget that. And then here, maybe the most important of all, you have to maintain the confidentiality of the closed session. We're not supposed to read in the newspaper the day after there's been a closed session meeting of what happened in the closed session, unless the body has authorized it. If they authorize disclosure, that's fine, but typically disclosure is not authorized. And this is not a situation where commissioners have the ability or the right to kind of leak information to a friend or to the media or whatever. That actually is misconduct and could result in a member being, essentially tossed from a commission. Finally, passive meeting bodies. This is a creature of the Sunshine Ordinance. It's not in the Brown Act at all. But the idea is that sometimes there are bodies appointed by the mayor or a department head or an individual commissioner. And they're sort of important in terms of the public knowing what's going on. And so that's the concept, that some of these bodies that don't have to operate publicly under state law do have to operate publicly because of the Sunshine Ordinance. This also covers social, recreational, ceremonial occasions by or for a policy body with a majority of the body being invited. For example, December holiday party. And there are certain employee committees that are responsible for formulating city policies which will be considered passive meeting bodies. The definition of a passive meeting body is quite complicated and not clear in certain circumstances. So again, this is an area where there's a lot of value in checking with the deputy city attorney. The basic passive meeting body rules are outlined here. That the passive meeting body gathering, it's called a gathering, it's really a meeting of the passive meeting body, has to be open to the public. This is the most basic rule. And as I mentioned, this is why we have this designation of passive meeting bodies under the Sunshine Ordinance. so that the public can see the operations of these bodies that are not technically policy bodies under the Brown Act, but that still are important in terms of their impact on public policy. There has to be disability access. This next one is important. There has to be notice on the departmental website or the commission website, whatever it is, the mayor's website, if possible. Other notice if requested. Usually it's going to be possible to have notice of these passive meeting bodies, gatherings. No agenda is required, but if one exists, it has to be provided on request. But, and this is a good contrast with the policy bodies and the normal rules, you don't have to follow the agenda. It's more like an informal thing. And here, this is critical, there's no right of public comment at the passive meeting body gatherings the way there is at the meeting of a policy body. So that's it in terms of our summary of some of the basic principles relating to open meetings law. We now will move to public records. This is the other half, and it's probably obvious, but the first part of the presentation regarding open meetings is more relevant to members of boards and commissions, although it's certainly important that department heads know about all those rules because of all the interaction that you as a department head have often with a board or a commission. The public records part, it's sort of flipped. It's kind of more important in terms of departments and department heads, but at the same time, members of boards and commissions need to be aware of these principles as well. Because, for example, if you're a member of a board and commission and you're texting during a meeting and then there's a public records request for texts of commissioners that occurred during such and such meeting, you're going to need to know these public records laws as well as anyone. In terms of our overview, we really cover three things: the definition of a public record, the process for handling requests, and then finally exemptions. Definition of a public record, the key thing here is it is extremely, extremely broad. It's any sort of writing regardless of physical form or characteristics. And writing does not mean, like something that's handwritten or something that's typed. It's any form of record. It could be a photograph. It could be a phone message. It's just anything that is in recorded form, regardless of the physical form or the characteristics. Second, with information relating to the conduct of the public's business. If it's your grocery list or something like that, and you happen to have it at your desk, that's not going to be a public record. But this concept of information relating to the conduct of the public's business is going to be interpreted quite broadly in order to further the open government principles. It has to be prepared, owned, used, or retained by any state or local agency, and of course that would include the city. And I highlight the third factor here, the prepared, owned, used, or retained. When you go through those four different words, you've kind of covered the waterfront. So you can just see from these four basic components of the definition, this is a humongously broad definition of what a public record is. And I mentioned before, and it's worth emphasizing here, doesn't matter what the medium is. If you have something that meets that definition of a public record that we just went through, it doesn't matter that it's on a personal electronic device or on your personal phone or anything like that. What the law does is consider the substance of the message, its purpose, context, sender, recipient. It doesn't say, personal electronic devices are off limits. Now, when there is a public records request, it's the responsibility of the relevant employee or official who would have or might have a record relating to the subject matter of the request. It's their responsibility to search their phone or to search their personal computer or whatever it is. And the request doesn't have to specifically ask for this. If it does, well, that's absolutely clear. But in most situations, if you have just a public records request that is generally stated, it will be understood that it includes public records regardless of whether they're recorded on a personal device or on a city computer, for example. And I've already mentioned the concerns about texting or email during a meeting. Let's talk a little bit in more concrete terms about the process for handling requests. First, what is a request? What is a valid request? Well, it has to specify a record or a category of records, but the important thing to know here is this is not a strict requirement. You don't have to have a public records request that I want to see the memo of such and such date from such and such person to such and such person. I mean, if you have that, that'd be a perfectly fine public records request. But no, that's not the norm. Typically, public records request will state a kind of a subject matter. I want all records you have pertaining to X or pertaining to Y. So it's not a strict requirement. Public records requests can take any form. We're used to seeing them in written form, but it's important to know that they may be oral as well, and that you can't disregard a request just because it came in orally or came in over the phone or something like that. It's a good idea if you have one like that for you as the department to then make a written record of what you understood the request to be, so it is reduced to writing by you if not by the requester, but it's not required. As a general rule, public records requests can be anonymous. This next one is important. The words used to categorize what is going on don't matter. It doesn't matter that somebody says this is a public records request. If they send in what is a request for records, it is a public records request regardless of whether it's called that. And it can be mislabeled. It can be called a Freedom of Information Act request. That's the federal public records law. That's not what applies to San Francisco, but it doesn't matter. All that matters is that you as a department can see that the requester is seeking a record or category of records. And finally, this last one is really important, and it's a little counterintuitive, but not really when you think about principles of open government. The requester does not have to state why they want the document. They don't have to justify getting the document. All they have to do is say they want this record or they want this category of records. It's sort of not the department's business why they want it. Types of requests. We can categorize requests by the method sought to access the record. There can be requests to inspect or request to copy. And you can have a sort of a dual situation. You have someone who wants to come in first to inspect a broad category of records, and then they somehow make a notation or a clipping or whatever of these are the ones I want you to copy. You can also categorize types of requests by the time frame for the response. There are standard public records requests, which is to say ones that are governed in effect by the time frames in the State Public Records Act. And then there are what are called immediate disclosure requests, and that's a special type of request that is recognized in the Sunshine Ordinance. If you have an immediate disclosure request, you need to respond to it by the end of the next business day. The idea is it's a very simple request. It's one document they need, or one small category of documents that's easily accessible. That's the concept. The standard public records request, the time to respond is 10 calendar days. And then for both of these, there's a time extension of 14 calendar days if it's not possible really to satisfy the request within the first time requirements. Finally, there's a creature of the Sunshine Ordinance called a request for description of records. And that's where it's not a public records request, but it's rather, I want you, the department, to take such and such subject and tell me the kinds of records you have about it. And then that can form the basis for my going ahead and making more particular public records requests. And under the Sunshine Ordinance, that has to be responded to within 7 calendar days. Now, you remember back with the agendas, I said, well, you know, what's important here is two things. Get the agenda out earlier than 72 hours and make sure that the descriptions are good. Well, here, the moral of the story with respect to public records is start working on the public records request right away. You know, those days click away very quickly. There are other things that departments have to do than respond to public records requests. It's easy for them to not necessarily be at the top of the pile, but that's in the context of laws which require that they be at the top of the pile. So it's very important to get moving on this stuff, because when you get a public records request, what you need to do is figure out who within your department are the right people to contact that might have responsive records, and you need to figure out which files within your department need to be consulted. And so it takes some time to get all that done, and what you need to do is start working on the request right away. As I mentioned before, there can be extensions of time for different reasons. The records that have to be researched are voluminous. It's kind of an imprecise standard. What does voluminous mean? How big is big? If the records are in off-site storage, that can delay getting records. If it's necessary to consult with another department within city government or another agency, that can be the basis for an extension of time. And with respect to electronic data, if there's electronic data that a department has, but it's not organized in a particular way that would provide to the requester the information required, there may be a need for more time to compile the electronic data in a way that is feasible. Now, there are nuances to all of these time issues. There are going to be some public records requests that are so big you can't meet the time requirement. It's not something that you should take advantage of. You should do everything within your power to meet the time requirements, but sometimes it's not possible. And sometimes with a massive request, you have to tell the requester you're not going to be able to make that time. What you should do is get records to the requester on a rolling basis, so there's some responsive records provided within the time frame. Produce the records on a rolling basis, and kind of operate in good faith according to these kinds of standards. I don't want to emphasize this too much because the thing that bears emphasis is meeting the time requirements, but I also want to be realistic and acknowledge that sometimes that's not possible. I also want to emphasize or mention at least that the simple fact that something is called an immediate disclosure request does not make it so. Sometimes an aggressive requester will just slap the label immediate disclosure request on any request. And it might be a request for a category of 1,000 documents or something like that. We don't really consider that immediate disclosure request. We would say to the requester, this is really a standard request and will adhere to those time limits. Now again, as a department, you don't want to abuse that. You want to do your best to meet the time for immediate disclosure request, but a requester can't just by fiat make something an immediate disclosure request when it really isn't. There is a duty under both state law and our Sunshine Ordinance to assist requesters. It's very important for departments to understand this is not a litigation type situation where you're at odds with another party. The concept of the Public Records Act is a cooperative relationship between the requester and the government. And 8 out of 10 times, 9 out of 10 times, I think that's how it works. There are some instances where it doesn't work that way and it becomes an antagonistic relationship. But the law recognizes, regardless, there's a duty to assess the requester. If a request is unclear, you ask them to clarify it. If there is one of these open-ended requests that is going to call for 1 million emails or something like that, what you should do is work with the requester to narrow it. In many situations, I would say a majority of the situation, the reason there's an open-ended request is either the requester didn't do a good job of wording their request, or they were afraid they might unduly limit it. But when you find out what the requester is really looking for in terms of documents, they often are amenable to narrowing the request. You have to assist the requester with identifying types of records that exist. If there are records in another department, you're Department A, you're a big department, and Department B over there is also a big department, and you as Department A get a public records request and you know Department B has a lot of records that would be responsive. What you should do is immediately contact the requester and tell them, hey, Department B has a lot of these records if you want to direct your request there. And you still, of course, as Department A would have a responsibility to provide those responsive records you have. There's a duty to conduct a reasonable search. Now, what does reasonable mean? That's one of those words in the law that, you could go 100 years, you could never really define it. It's a matter of degree. You don't have to seek the proverbial needle in a haystack. You do have to, what I mentioned before, consult the relevant people and files within your department. You need to keep your records in orderly files so that you can make a meaningful search. And as I mentioned before, when we're talking about personal electronic devices, it's important that the individual employees or officials who are searching those devices have a kind of a comprehensive method of doing so. Fairly recently, the former mayor of San Jose got in a lot of hot water in a lawsuit because there wasn't really an adequate search of the personal phone. And so these situations can come back to bite you if you don't take seriously the duty to conduct a reasonable search. There's no duty to respond to written questions. It may or may not be a good practice. This is something departments have to gauge sort of on a case-by-case basis. You want to be helpful to the public. In some circumstances, it may be more prudent not to respond, but I don't want to be seen as encouraging that. We want to encourage, obviously, good relationship with the members of the public who government serves. There's no duty to create a record that doesn't exist, or if a record has been destroyed through a lawful records retention policy, there's no duty to recreate it. But it's important to emphasize this is sort of an old-fashioned standard that applies to hard copy documents. As I mentioned before, the laws with respect to electronic records are a little more complicated because electronic data can be compiled in certain ways and then kind of rearranged in order to provide the requester with what they need. So there are different standards there, and this again is an area where it's often useful to contact the deputy city attorney and see how to handle it. There's no duty to create a privilege log that when you're denying a records request to say, well, there are these specific records we're denying. Sometimes people get confused about that because there can be situations where you are, for example, in litigation, where there is a duty to create a privilege log, but at the beginning stage of public records requests, there's no such duty. What are the possible responses? Well, the response should always be written. It's legally required that it be written if there's any sort of denial or partial denial. Technically, I'm not sure if it's a legal requirement to be written if you give all the documents up, but obviously you want it to be written so that you have a record, so if there's any question down the line about the records you provided, etc., you'll have that taken care of. What are the options? You've done this search. Well, maybe you did the search and there's no responsive records, in which case that's what you say. Or you've done the search and there are responsive records. It's sort of a binary choice there. There either are or not responsive records. Where there are responsive records, well, what are the options? You disclose all the records, you disclose some of the records, or you disclose none of the records. Within a record, you either disclose the entire record or you may redact. So there are all those possible permutations and combinations about the nature of responses. And if you withhold a record in full or part, you have to state the legal justification. And you have to explain the process for the requester to inspect and or copy the records. Of course, that doesn't, it depends on the circumstances. If you're just providing the records, then obviously this is unnecessary. But if it's sort of the first step in the process, we've gathered all these records, come in at such and such a time to inspect them, or here's the arrangements we'll have for getting you the copies, then you need to explain that. You need to state the copying fees, if any, but the important thing to emphasize here is that given our Sunshine Ordinance, there's not too much you can charge as far as fees go. 1 cent for a routinely reproduced item, 10 cents for other records. More if you have an itemized cost analysis for some sort of record that's 11 by 17 or 3-dimensional or something like that, I don't know. If it's a medium, the cost of the medium, videos of meetings no more than $10 per meeting. You may not charge for the search time. You may not charge for the time redacting records, for overseeing inspection. Let's say somebody's inspecting records and you need to sit in the same room with them or something like that. You can't charge for that. You can't charge for time to copy records. You can't charge for time preparing responses. So you can't charge for very much. Finally, we deal with exemptions. And this is one where, if you go back to the very beginning of the presentation, I said, there's no way we can cover every issue. Well, this is particularly true with exemptions because there are so many possible exemptions out there. We can just give you a brief sketch. The Sunshine Ordinance has limited the ability of the city to invoke certain exemptions. We can't do what's called general balancing, where there's not a specific exemption in the law, but just kind of on balance, it's better not to disclose. We can't do that. We can't rely on the so-called deliberative process privilege, and there are certain contract-related documents that under state law we probably could withhold, but under the Sunshine Ordinance we have to disclose at least earlier than state law would require. But many exemptions still exist, and I'll just give you a laundry list without even attempting to get into the substance of any of them. Privacy is the most important one of these. Private information, including personal contact information, generally you don't disclose that. Personnel records, generally you don't disclose it. There are special rules for peace officers that are both, in a sense, more protective of privacy, but in recent years there's been some modifications of those rules to allow for greater disclosure. Medical records, obviously there's a high premium on privacy there. Trade secrets for businesses. It's not a slam dunk. You can have a trade secret, but still the law in some circumstances will say it has to be disclosed in the public interest. If there are complaints from informants, complainants, whistleblowers, those are typically protected. Attorney-client communications under the attorney-client privilege, the attorney work product, and then you go on and on. Library circulation records, real estate appraisals, test questions for civil service tests, and for that matter, non-civil service tests, law enforcement investigative and security records. And that's only a small fraction. There's a huge number of exemptions. Many of them are listed in the Public Records Act, but if there's a confidentiality requirement or a confidentiality privilege in anywhere else in state or federal law, that's incorporated into the public records regime. Many of these things are obscure. And what I like to tell departments is, operate on good faith here. If you have a good faith gut check that there's something problematic about disclosing this, well, check with the attorney and maybe there's some obscure exemption. But it's important to also emphasize non-starters. There's no embarrassment exemption. I mean, record's going to be embarrassing. Again, that comes with the territory. There's no exemption, it'll hurt the city in litigation if we disclose this. There's no exemption, it's a hassle to comply. Certainly burdens can affect the timing of the response, as I alluded to, and discussion with the requester can lead to a narrowing of the request, as I mentioned. But this is limited. There then are waiver exemptions. I apologize, I forgot to eliminate that from the prior slide. That was that little text at the bottom there. But this is a really important principle as far as public records go. And that is that if you disclose a record to requester A, you have to disclose it to requester B. You have to treat requesters equal. And again, going back to that principle that the purpose of the request doesn't matter. You can't disclose it to requester A because you think they're responsible, but not requester B because you think they're irresponsible, anything like that. And this means that when you get the first public records request concerning a particular subject, you need to kind of make a judgment there, generally with respect to the record, whether it's something to be disclosed or not. There are some exceptions to this waiver principle. For example, certain disclosures to other governmental agencies doesn't mean you then have to disclose it to members of the public. And it doesn't apply if there's been an illegal disclosure. Let's say inadvertently you disclosed a document that had somebody's social security number in it. Well, that doesn't mean their social security number is compromised for every subsequent requester. And the law has said in some cases where there's an inadvertent disclosure, like an inadvertent disclosure of attorney-client privilege materials, that doesn't constitute a waiver. Finally, and I spend very little time on this because the premise of this training is that everyone watching this training is committed to open government principles. And we want to maximize compliance both with the letter and the spirit and minimize the inadvertent violations. But just so you're aware, under the Brown Act, a willful violation of having the intent to deprive the public of information which it's entitled, sort of generally stated, is actually a crime. And as I mentioned before, an unauthorized disclosure of a closed session discussion could lead to removal from office. If certain actions were taken at a meeting in violation of certain provisions of the Act, then they can be voided by a court. A court can have injunctive or declaratory relief to stop or prevent violations of the Act, and litigation can involve attorneys' fees and costs. Public Records Act, the requester can file suit, get declaratory and injunctive relief, ordering the city to disclose the record. And in the Public Records Act context, the key thing is that attorneys' fees and costs can mount very quickly. And you can have public records litigation that gets into the six figures in terms of attorneys' fees and costs. So in addition to one's commitment as a public official or employee to principles of open government, there should also be a commitment to fiscal responsibility, and that really kicks in here with respect to public records. Finally, I note that under our Sunshine Ordinance, we have a task force which has broad jurisdiction to hear complaints of open government violations. And this is really an important innovation, because otherwise the member of the public who's frustrated with the response to a public records request or conduct at a meeting, their only recourse is to go into court, and that costs a lot of money, and you have to hire a lawyer. You don't have to. You could proceed, on your own, but it's a kind of hassle which is not really relief that's available to a lot of people. The task force does provide a forum for hearing these complaints. If the task force finds a violation, what they will do is ask the department to cure the violation, and they will refer the matter to the Ethics Commission if they consider it a willful violation. And then the Ethics Commission will look at it more closely with possible sanctions. That's basically it. For further information, as I've emphasized, contact the City Attorney's Office, which as a practical matter usually means contacting the Deputy City Attorney assigned to your department or commission. And in addition, as I mentioned, the Good Government Guide on the City Attorney's website. We're in the process right now of revising the open meeting section of that, but it's a good overall guide to most of the principles. I want to thank you for joining this training. I know all of us have this common mission of adhering to these open government principles, and I hope that this presentation has helped sharpen your understanding of those principles. Thank you.